Fuddle. I have three claims I'd like to discuss today. Sufficiency claim relating to the false report to the police officer, claim relating to the value of the insurance fraud claim, and a sufficiency claim about the insurance fraud claim. Before I turn to those, I don't want to talk about the facts. I would frame this case, though, by saying it was a pretty, on the surface, it's a fairly simple case. I think if you read it closely, it becomes somewhat mystifying in the sense of how the state presented its case, which witnesses it called, what those witnesses said, what questions were asked to the witnesses, ended up with a lot of questions as to what the state was alleging, what actually happened. I just say that not to make a specific point, but just to alert. And I think a lot of the issues I am addressing sort of arise out of this sort of state of confusion of what was even being claimed to have gone wrong. The first issue I want to talk about is relates to count one. The charge was Mr. Fletcher made a false report to a law enforcement officer. The claim that we are making here, I hope, is a straightforward one that depends merely on the language of the statute. False report to a law enforcement officer is the crime. A separate section in that definition section provides a specific definition of a law enforcement officer, meaning an officer, agent, or employee of the government. And there's sort of two parts that I think are important. The first is the person has a duty imposed by law to, and then the second part that is important, the duty is to maintain public order, make arrests for offenses, or investigate offenses. The state's theory at trial was that Mr. Fletcher had called and talked to a cadet named Tyreek Campbell. Mr. Campbell, who was an officer at the time of trial, for sure, I think no longer an officer, but he testified at trial as to this interaction with Mr. Fletcher.
Mr. Harwell, didn't Mr. Fletcher actually call the Knoxville Police Department first, and then the cadet was placed in touch with him?
I think the evidence is he I don't know whether he called 911, called the teleserve number. He made some kind of call, no one was available, and then the cadet called him back.
Okay. So how is this distinguishable from the 911 cases? So if I were to make a phone call to 911 to report a crime, in your view, that could not be a report to a law enforcement officer, is that correct?
It depends on what the proof is to the person on the other end. If sometimes they patch through to an officer. I believe under this statute that may be some crime. Under the law, that may be some crime if the dispatcher on the other end of the 911 call is just taking that information, but that person is not a law enforcement officer.
Let's assume that the person taking the call is just an employee of the Emergency Communications District, not an otherwise member of law enforcement or law enforcement officer as it goes. Is there any authority that would hold, even under that circumstance, though, that a call to 911 to make a false police report still would give rise to criminal liability under this statute?
I guess I haven't actually seen cases that were just 911 calls. The state did cite a case involving a 911 call in its brief, but that was a case where police officers came and talked to the individual as well. Okay.
So that's the Montgomery case. And so the distinguishing fact in Montgomery is that you had initiation of a call to 911, but then you had law enforcement officers then come on to the scene and then take the report.
That's my argument, yes.
Okay.
And I think that is the consequence of the language of the statute, that there is a specific definition of law enforcement officer. It's not anyone working in the law enforcement regime. It is someone who does certain tasks and also has a duty imposed by law to do those tasks. Here, the only evidence we had about Mr. Campbell as to what a cadet does was that sometimes he wrote parking tickets or was in the teleserve unit or helped out the property unit. So as to the two parts of the statutory test, I think it failed both. There was no showing that he was maintaining public order or investigating or making arrests. But more importantly, perhaps there was no claim, there's no evidence, and not even any claim on appeal, that a cadet has a duty imposed by law to perform those tasks. So
the issuance of citations there strikes me that is a law enforcement function. And so is the argument then that even if that is even if he is charged by law with enforcing that type of law in a law enforcement capacity and a law enforcement function, that is still not an agent of government for investigative purposes?
I don't know that I accept that writing parking tickets is the same as maintaining public order and making arrests and investigating. But even if it is, you have the further requirement that it has to be not that someone in the police department asked him, tasked him, told him to go write parking tickets. There has to be, by the statute, meaning something that has to be proven at trial to the jury, there has to be a legal duty that was imposed on him to do that. And there is no proof in this record that a cadet has a legal duty to do those tasks.
What about the fact that the cadet reported the defendant's report to the cadet's supervisor? What impact does that have on the defendant's liability for making a false report?
I think none. The statute says to make a report or statement to a law enforcement officer. Perhaps there could be, and this goes back to the 911 situation, if the dispatcher is saying, like, I'm calling somebody else and I'm putting them on the phone and telling them what you said, maybe you could get there. But we certainly don't get there in this case because there's not a hint in the transcript that this was the state's theory. The state's said clearly in opening statement, the police report was to Officer Campbell. Frankly, I think the state completely overlooked that the Officer Campbell they were putting on the witness stand was testifying about a time when he was not an Officer Campbell yet. He was Cadet Campbell. And that's...
Did the cadet supervisor follow up in any way with the defendant? Did anyone with the Knoxville Police Department or otherwise follow up with the defendant after the cadet's report?
There is no... The cadet says that he informed his supervisor, put some kind of bolo into the system, and that is the sum and total of information as to what happened after that. There was no questions about further contact, about what did your supervisor do, about any further investigation. That was the state presented the conversation between Mr. Fletcher and the cadet and moved on to other subjects.
Thank you.
I also will move on to other subjects. And this is, again, an issue of what does the actual statutory language mean, rather than what do we think a reasonable statute should have said, or what do we think the legislature probably meant. And this has to do with the charge of insurance fraud. 3914-133 says insurance fraud is punished as in the case of theft, meaning go look at the theft statutes to see how severe the punishment is. We look at the theft statute, 3914-105. Theft of property or services is the relevant category here, was a Class D felony if the value of the property or services obtained is $2,500 or more. So statutory language says what is the value, further statute says it was sort of fair market value of the property or services obtained. And here there was no dispute from either side that there was no property or services obtained. There was a claim, which claim it was, what the value was. I guess there was confusion as to what that was. But there was absolutely no dispute that Mr. Fletcher never got anything.
Do you think that's required? An actual loss?
I don't think it's required for it to be a misdemeanor, so for it to have a value of 0. But for it to be a D felony, the property or services obtained has to be above $2,500. And I think my intuitive response perhaps is the same as what the court's response will be of, surely that's not what the legislature meant, right? Surely they meant that we look at the amount of the claim and punish it in that way. But that's certainly not what the legislature said. Legislature said, punish it like theft. That's theft statute says, look to property or services obtained. And here we have no properties or services that were obtained, and therefore it's punished as if the value was zero. The most helpful thing on this point, I think, in a way, is to look at the bad check statute, which is sort of a very similar analog of you're trying to get money you're not entitled to, and you do something, and maybe it gets honored, maybe it doesn't get honored. It's interesting that in that context, the legislature, instead of just having a cross-reference to the theft statute, it has that exact same cross-reference. The offense of issuing or passing worthless checks is punishable as theft under 3914-105, but then it says value shall be determined by the amount appearing on the face of the check on the date of issue. So when you're talking about a bad check, the legislature says, don't just have a cross-reference, we're going to change it so that you look at the amount you wrote the check for. And so even if you didn't get anything, if you wrote a $10,000 bad check, you're being punished for $10,000. That kind of language is exactly what is not in the insurance false claim statute. We don't have anything saying, look at theft, but use as the value the amount of the claim that is being made. And if you don't have that, then we're left just with the language of the statute. It's the property or services obtained. As I said, there's no dispute. Geico never paid a cent to Mr. Fletcher. Maybe that's not how we would have written the statute. Maybe the legislature needs to be reminded of this and fix the statute, but as it stands and as it was presented here, value is zero. The worst that Mr. Fletcher could be punished under this statutory structure, even if you believed everything the state was saying, would be as a misdemeanor.
Under your comparison, though, you used the bad check. You don't agree that the proof and support of such claim for the payment of a loss would cover what you just stated? That the claim was for the payment of the $9,500 or whatever the claim was in this case?
I don't think so. I think we are stuck with 3914-105 saying the value of the property or services obtained. So it's not property or services claimed, property or services sought, it's property or services obtained.
How do you distinguish? I'm sorry.
The bad check is really similar to a claim, an attempt to get the money, even if it's not paid, right?
Yes.
Okay. And a claim is just another document or claim made to try to fraudulently obtain the money, the amount requested, right?
Yes.
Okay.
I'm saying that the bad check statute fixes this intuitive problem, but just for the bad checks statute. There is no fix. If it's a problem, maybe the legislature entirely is happy with this. Who knows?
Well, there's some reason to believe that's the case, right? Because didn't we in Gothard some time ago in 1999 interpret the statute in exactly this way?
I don't know that I would agree that there was any issue was raised as to, well, there wasn't actually any payment on the claim.
But those were the facts in Gothard.
Definitely were the facts. It's an unpublished decision. That is the outcome it reached. But there were arguments made, but there was no argument that the value of services obtained was zero. So it's certainly persuasive authority. I just think its value should be less than us taking a new look at what the statute actually says.
Okay. I mean, all right, fair enough.
The final argument, and this will be relatively brief, is to the sufficiency about the insurance, the fraudulent claim issue. And I probably won't be able to state this as clearly as I had said in the brief, but one of the mystifying things about this is that the document that the state introduced very early in its case went over in great detail, focused on as the essence of its fraudulent insurance claim argument was a document that was submitted on December 15th. And it listed the facts that Mr. Fletcher was alleging to have occurred. The other document that the state focused on and introduced was an estimate prepared after that was submitted. The weird thing, the mystifying thing is before December 15th, the vehicle had been recovered and found it had damage to it. It had tires that were slashed and leather seats that were slashed. So at the time the document was submitted, the vehicle was no longer lost. And Geico knew that. And in fact, Geico's response to this document was to prepare an estimate about the damage to the car, not a replacement, but this is how much it would cost to fix the leather seats. So the state did not prove to the jury beyond a reasonable doubt that when Mr. Fletcher submitted this document to Geico after the car had already been recovered, that he was somehow trying to recover the value of a stolen car. It wasn't, maybe it had been stolen before, but no one thought it was still stolen. They had the car. And Geico knew that because Geico's claim estimate, which it never paid, but what it was estimating it would pay if it did pay, was to repair that car. And the state never proved, if that's the claim, this after the car is gone, what is insurance supposed to cover? The state never proved that there wasn't some validity to the tires being slashed and the leather being slashed. So again, it's a byproduct of the mystifying way that the state presented the case, but the claim they actually focused on, even under their theory of the case, wasn't a false claim. And I will reserve the rest of my time for rebuttal.
All right, thank you, Mr. Harwell. Mr. Ward?
Good morning, Your Honors. May it please the Court. My name is Garrett Ward. I'm here today on behalf of the state of Tennessee. Your Honors, opposing counsel frequently referred to the facts of this case as being mystifying. I'd like to talk about the facts for a little bit because I disagree. I don't find the facts of this case all that mystifying at all. I think this is a relatively straightforward case. The defendant had what he thought was a clever idea to get some money from his insurance company. And to get this money, the defendant told an employee of his, a man named Mr. Metcalf, asked Mr. Metcalf to take him to a local cafe for lunch, and then told Mr. Metcalf, okay, rather than leave this Hummer SUV at the cafe, drive it to some nearby apartment complex, leave it there, and bring back some other truck. There's some proof in the record that Mr. Fletcher may have done some work at that apartment complex. So he has another vehicle there. So he tells Mr. Metcalf, go get this other vehicle and bring it back. What Mr. Metcalf testifies to, or what the proof shows, is that while Mr. Metcalf is running this errand for his employer, what his employer does is two things that are criminal in nature. First, he calls the Knoxville Police Department to report the vehicle is stolen. And second, he calls his insurance company to similarly report the vehicle as stolen. Ultimately, Your Honors, this scheme is unsuccessful. Taking this Hummer to an apartment complex a few blocks away that was a location where the defendant had done some work, ultimately turned out to not be a good way to convince your insurance company and the Knoxville police that his vehicle was stolen. But in his attempts to sort of successfully perpetrate this fraud, the defendant violated both the false report statute and the making false insurance claim statute. Those are the facts, and I think it's really not much more complicated than that.
General, to whom did Mr. Fletcher make the original report? Did he call the precinct of the Knoxville Police Department? Did he call 911? I'm not able to figure that out clearly.
From my understanding of, and this is from the defendant's own accounting of events, he called the police department itself and spoke to a civilian of some sort. This civilian told him, essentially, I'm not the right person to do this. I'll have somebody who does handle these sort of like vehicle thefts, property crimes, call you back. And then he receives this subsequent call from law enforcement. That's his testimony, but I think really the heart of Your Honor's question is, did the defendant reach out to the police department? And he did. That's how he characterized it. maybe that was sort of an artful testimony on the defendant's part. I can't actually say, but what the evidence shows is that from the defendant's version of events that he reached out to the police department and spoke to someone, and that person, that initial identity isn't really discussed.
Your friend on the other side suggests that when the person who returns the phone call to Mr. Fletcher, after Mr. Fletcher has called the police department, hasn't gotten in touch with the right person, is told someone will call him back, and someone in fact does call him back for the purpose of taking a report, that person cannot be a law enforcement officer under the definition because there was not sufficient proof at trial that the cadet had a duty imposed by law to investigate offenses. What's the best argument and response?
So I've got sort of two responses to that, Your Honor. First is I disagree with the contention that Officer Campbell, at the time he received this report, didn't qualify as a law enforcement officer for purposes of the statute. And secondarily, I think even if Officer Campbell didn't qualify at that moment, that's really immaterial given the nature of what the defendant did. But first, I'll address Officer Campbell's status. The false report statute does define law enforcement officer as somebody with the duty to, do certain things. And really, the requirement is a duty to maintain public order or make arrests, accompanied by the duty to investigate crimes. And I don't think there's much dispute that Officer Campbell's duties at the time this call was received fell within that sort of broad spectrum of the statute. What Officer Campbell testifies to is that during his time as a cadet, he was responsible for helping out with property crimes, for issuing certain citations, for manning the teleserve unit. Essentially, he described himself as being involved in the maintenance of public order, and then, having at least some involvement in investigating these crimes. So I think that portion of the definition is relatively easily met.
But he's an employee. He's not some volunteer with the police, correct?
Correct, Your Honor.
And does the record show how a cadet becomes an officer, or what a cadet's responsibilities are?
And I think Your Honor's question gets sort of to where my friend's chief, problem lies. The record is not expansive on that point. The record is clear that that Officer Campbell is an employee of the police department at the time he receives this call. He's not a volunteer. I'd say the record is similarly clear that he is something more than a civilian. What the evidence shows that there was initially civilian involvement, and then that person stepped back and, reached out to somebody that was the proper person at the Knoxville Police Department to do this. There is not a lot of testimony from Officer Campbell about the day he became a cadet, because that was his classification at the time. Not a lot of testimony about what that initial process was like. He does give testimony, as I said, about his duties, and frankly, based on the way he describes his duties, it makes sense that he was the person to, handle this stolen vehicle report. His primary description of his duties are manning the teleserve unit and investigating property crimes, which is precisely what he does here.
And the statute doesn't require him to be a sworn law enforcement officer, right? It's only that he be an agent of government.
Correct, Your Honor, with a duty imposed by law, which is less than a sworn law enforcement officer. I agree with Your Honor there. I think that, I'll contend to this court that the jury here is, presented with the description of what Officer Campbell is at the time of this call. An employee of the Knoxville Police Department who describes his duties as, encompassing the sort of behavior he takes in this case, who was reached out to by an initial civilian employee at the police department as being sort of the principal person, the primary person who should initiate the investigation into this stolen vehicle. I think viewing all of that evidence in the light most favorable to the state, the jury could conclude that Officer Campbell was a law enforcement officer for the purposes of that statute. think that is the most straightforward way for this court to dispose of this challenge. But, Your Honors, even looking past that, I think we maybe lose the forest for the trees here a little bit with this question. The defendant's behavior in this case is to call the police department to lie about his vehicle being stolen. That's sort of the heartland of making a false report. The state points to a case in its brief where I believe the Tennessee Supreme Court or this court commented that the false report statute, really one of the primary evils it deals with is false reports about stolen goods. This exact sort of situation. The defendant here makes a deliberate decision to reach out to law enforcement to tell them his vehicle was stolen, knowing that his vehicle wasn't stolen, that it was at the apartment complex he told his employee to take it to. That is the exact behavior that the false report statute seeks to prohibit. It's exactly what the defendant engaged in. I think this court could just as easily look to that and conclude that that is filing a false report. Judge Greenholtz, you asked opposing counsel about how distinguishable is this from 911 cases. I think there's very little, if anything, to distinguish this from 911 cases. In both of those scenarios, a person seeking to mislead law enforcement about some incident reaches out to an avenue of communication that exists solely to communicate with the investigative bodies and functions of law enforcement.
So your friend on the other side, his rejoinder to that, as I understand, is that the crime of false reports doesn't arise merely because 911 has been called. It arises because contact's been made with 911, and then law enforcement officers, who otherwise would meet the statutory definition, are responding to take the report, and when they respond to take the report, that's the point in time in which all the elements of the crime come together. That it's not merely just the reaching out. So what would you say in response to that argument?
I think there, Your Honor, perhaps we're even in a situation more similar to what we have here, is that we did have someone from law enforcement reach out. We did have this initial call to the civilian. Perhaps that's not good enough. Then we have Cadet Campbell reach out. Perhaps under opposing counsel's theory, even that's not good enough. We then have that deliberately communicated to sort of higher bodies in law enforcement. That's the intention of this contact in the first place. If Officer Campbell isn't good enough for this crime, which the state does not agree with, the purpose of making this contact in the first place is to get the wheels of investigation rolling based on a false pretense. That is the intention of the defendant. I think sort of taking that initial step, making that report, and sort of sending it on its way to law enforcement is sufficient to trigger.
So what happened with the supervisor then? That's unclear for me in the record. So it looks like the cadet reports it to his supervisor, but I can't tell what actions followed from that. So did the supervisor say, for example, will Cadet Campbell go and handle this? Did the supervisor say, thank you for the report, we'll take it from here? What happened?
There's not a lot in the record on that point, Your Honor. There is, like opposing counsel said, there's a BOLO issue. The vehicle pops up in NCIC. And although the exact mechanism is unclear, ultimately law enforcement does, or ultimately this car is found. But as to what specifically the supervisor said to Officer Campbell, I can't speak to that.
That's fair enough. Thank you.
I'll turn to, if this court has no further questions on the false report issue, I'll turn to the insurance fraud claim, and I'll start with value. And Your Honors, I think this question can be rather readily dispensed with. Judge Wilson, you commented earlier that isn't this statute that's making false or fraudulent claims? Isn't this about criminalizing attempts to get money under false pretenses? That's exactly right. That's the evil this statute seeks to prevent. So the punishment needs to be based on the evil that the statute seeks to prohibit. Admittedly, the insurance fraud statute, when it comes to gradation of itself points to the theft statute. It seems relatively elementary that the theft statute, when discussing itself, talks about goods or services stolen, because that's the evil the theft statute seeks to prevent. That's not what this false claim statute is about. False claim statute is about fraudulent attempts to get an insurance company to pay out money. Suggests that it would rather frustrate the intent of the legislature to apply this sort of odd valuation mechanism that would require a successful scheme in order for it to be graded as anything more severe than a misdemeanor. And this court, as Your Honors noted earlier, has dealt with this issue before in Gothard. I think the court got it exactly right in Gothard. But perhaps even more to the point, the Tennessee Supreme Court pretty recently in State versus Mitchell, which I believe is a 2019 case, commented on this issue. So allow me to just lay out the factual situation in Mitchell a little bit. The defendant there had a homeowner's policy that he obtained. Just a couple days after obtaining this policy, there was a fire at the policyholder's home. He then submitted a claim saying, I need to be paid back for my under my policy because my home was damaged or destroyed. The insurance company refused to pay it because they said, they investigated. They said, this looks like arson. We don't cover your own arson to your own home, so we're not paying you anything. The Supreme Court that in Mitchell upheld the sufficiency of the evidence. It overruled an opinion from this court and upheld the sufficiency of the evidence there. Specifically, the court in Mitchell, the Tennessee Supreme Court in Mitchell, upheld the sufficiency of the evidence for insurance fraud at a valuation between $10,000 and $60,000. The defendant in Mitchell did not receive anywhere between $10,000 and $60,000. He didn't receive anything under the policy. There was some small good faith payment made to him around $1,000. But he received nothing under the policy. So clearly the Tennessee Supreme Court does not think the valuation of insurance fraud sort of depends on the amount insurance pays out. It depends on the claim. This court should follow that guidance here.
As I'm looking at Mitchell now, it doesn't appear that was actually at issue in Mitchell, the valuation. Do you agree with that?
That's not precise. I agree, Your Honor. The principal issue in Mitchell is whether it's sort of an archaic point or an arcane point about what does it mean to make a claim. But I point to Mitchell as the Tennessee Supreme Court at least finding no issue with it, even if it wasn't raised. So between Mitchell and Gothard, I think there is a good deal of case law, both binding and persuasive, on this point.
Okay.
And I think that both of those findings make sense when considering the nature of the statute at issue. Turning lastly, Your Honors, to the sufficiency of the fraud itself. This is an interesting issue, Your Honors, because the defendant really committed the offense of making a false or fraudulent insurance claim continuously for about a week. On December 7th, the defendant calls his insurance company, lies about his vehicle being stolen. Around a week later, on the 15th, I guess 8 days, he submits a vehicle theft questionnaire where he describes the theft, the time and date of the theft, the nature of the circumstances. In between there, he files some sort of official claim paperwork. We don't know exactly what it is, but the defendant himself describes having Mr. Metcalf take him to his insurance office to, and I quote here, finish the paperwork. Really, opposing counsel here focuses on the fact that sort of middle piece of paperwork is missing. But, Your Honors, that's simply not required for there to be sufficient evidence of this offense. Under the false claim statute, a defendant has committed the offense of making a false insurance claim when he really takes any step to make this claim or to put on any proof in support of this claim. So, Your Honors, in making this call and reporting his vehicle stolen, the defendant has committed this offense. He continues to commit this offense when he travels to his insurance office to finish the paperwork, and he still continues to commit this offense when he fills out a vehicle theft questionnaire about a vehicle he knows to never have been stolen.
But help me with that, though, because I thought that count 2 of the indictment, though, charged specifically the events on December 15
It says
as giving rise.
on or about. Your Honor,
Or
is
about December 15. Count 1 of the indictment, when it's charging the false reports to a police officer, is the 7th day.
I'd agree with that characterization, Your Honor.
Okay. But you're saying that even though the language of the indictment says on or about the 15th day of December, that we could still properly look to the 7th and thereafter?
I think we can, Your Honor. On or about is, it's not it doesn't pin the state to a date there. And really, when we're looking at sufficiency of the evidence, the state's evidence shows that he commits this for about a week immediately prior to December 15th. But even if the state's indictment does limit it solely to evidence on December 15th, which I note it does not, we would still have sufficient evidence because this vehicle theft questionnaire is just another link in the chain where the defendant is suggesting to his insurance company that his vehicle was stolen, that he needs money based on that theft.
Okay.
As far as the different values he discusses, those don't truly matter for sufficiency of this evidence. Although the amount he says his insurance company owes him changes from time to time during this week. Throughout the entire week, the defendant tells his insurance company that his vehicle was stolen. They need to give him money. And that was a lie. Unless this court has any further questions, I would ask that you affirm.
At the risk of prolonging the argument, your friend on the other side didn't discuss the accomplice issue. As I
Certainly, Your Honor.
understand the how it was charged in the trial court, it was charged to have the alleged accomplice, his status be decided by the jury. So it wasn't the trial court saying, I hereby instruct you that this person is deemed to be an accomplice, his testimony has to be corroborated. What's the state's argument here in this case that the accomplice testimony does not need to be corroborated, either because he's not an accomplice or what's the state's argument in that regard?
So, Your Honor, your understanding of the record as far as how accomplice testimony was charged is accurate. Essentially, this was a situation like a lot of situations involving accomplice testimony where the potential accomplice did not get up on the stand and say, I am an accomplice to this crime. Rather, Mr. Metcalf got up and gave this testimony that suggested he was duped. Obviously, opposing defendant at trial was free to attack that. But really, the jury needed to decide for itself whether or not they believed Mr. Metcalf's story or whether they thought Mr. Metcalf was just sort of covering for himself. But under Mr. Metcalf's story, he is undertaking a task given to him by his employer. That while he's undertaking this task, his employer reports this vehicle as stolen. His employer does tell him that when he gets back from this errand. So Mr. Metcalf is faced with this situation where his employer essentially says that I was doing something a little shady, but at no point, and it may be true that Mr. Metcalf doesn't immediately run to police at that moment, and maybe that would have been the most preferable course of action. But what we don't have in this record is any evidence suggesting that Mr. Metcalf intends to profit or really partake in the proceeds of this crime. He's not an accomplice in the jury properly.
If he is an accomplice, and Judge, I appreciate your lenience here. If he is an accomplice, what is the corroboration? They obviously find the car where Metcalf says they left it, but where's the other corroboration of Metcalf's testimony?
There's some corroboration from his testimony. There's a security video, Your Honor, that shows an individual walking in and out of this cafe. Mr. Metcalf and Mr. Fletcher's testimony differs on sort of who walked into the cafe, who drove to the cafe. So the jury could look at this video, determine who they thought the individual in the video was, and that is at least some level of corroboration of this accomplice testimony.
Is there anything else though outside of the video?
There's some stuff outside of the video, Your Honor. I'd say, particularly with regard to the manner in which the vehicle was found. Again, this is a vehicle the defendant alleges to have been stolen. The defendant maintains the entire time throughout the trial that he has the only key to this vehicle. when this vehicle is found, there's some damage to it, a back seat slashed, tires are cut open. It's not been hot wired, no forced entry, no broken windows. I think all of that, tends to, the security video tends to corroborate Mr. Metcalf's testimony.
Very good.
But again, his testimony doesn't need to be corroborated here because he's not an accomplice.
Thank you, Judge.
Thank you, Your Honors.
Harwell?
I think it's coincidental or interesting that there is a commonality to a couple of the arguments. I wrote down a few of the words that opposing counsel talked about in terms of the false report claim. Counsel talked about this being in the heartland of the conduct covered by the statute. It's one of the primary evils of what the statute was designed to cover. In talking about the valuation, counsel talked about punishment needs to be based on the value of what the total amount sought was. I think this is getting back to the issue, I guess the court has heard a couple of times today, of are we looking at this hypothesized intention of the legislature as what they were trying to accomplish, what the harms that they were hoping to criminalize were? Are we looking at the words in the statute? Particularly on the law enforcement officer issue, the statute says it has to be someone with a duty imposed by law to do certain things. We have had a trial, we have had briefing, we have oral argument. I still haven't heard any identification of what that law is that imposes a duty on Officer Cadet Campbell. As to, well, it got passed along to the supervisor. We have an issue, I think, that has arisen as to a couple of things that may be a good theory for appeal. I don't think it's even a good theory for appeal, but it's not the theory that we had at trial. Mr. Fletcher doesn't need to be finding out on appeal what the theory was for why he was convicted.
Mr. Harwell, what's your best argument that Metcalf is an accomplice?
Best argument that he's a Metcalf was an accomplice would be taking his testimony, even accepting it. He is told by Mr. Fletcher that a theft has been reported. The state has said that this was and somehow a continuing offense, that Mr. Fletcher, over a period of days, continues to engage in a false claim. The evidence, undisputed, I guess, was that Mr. Metcalf took Mr. Fletcher to Geico, was there with him while he filled out his paperwork. There was testimony he went with him to the impound lot to look at the car once it was recovered. And supposedly at this whole time that he is doing all of these things, he, according to the state, knows that none of this is true and legitimate, and he's assisting Mr. Fletcher in doing that. There is certainly the issue of testimony that he was owed some money by Mr. Fletcher and was hoping to get it back at some point. So I think that's the best argument as to accomplice.
So without the last part there, that he's owed testimony by the owed money by the defendant. Otherwise, it doesn't strike me that he could be indicted for any offense in the first instance.
I think if you know someone is intending to perpetrate a crime, and you're
all of his actions have been completed by that time, right?
Well, I guess that's what I'm saying. The state is saying it's continuous, it's ongoing. That all of this time period, when Mr. Fletcher is going to Geico, interacting with the police, going to the impound lot, that this whole time period is the crime. I guess if so, Mr. Metcalf is assisting him, taking him places, assisting him throughout that time period. Okay. All right. I guess I say that with a little bit of hesitance because I don't agree with the continuous crime theory that the state has put forward today. As Judge Greenholtz, as you noted, the two counts of the indictment are different. One says December 7th, one says December 15th. One assumes there's some reason. And to the extent that the state's theory was that the false insurance claim did not occur on December 15th, but actually had occurred back on December 7th, I would point the court, and this is one of the many mystifying things that I began by talking about. There was some testimony by Mr. Fletcher as to going to Geico to fill out paperwork. But the state didn't introduce anything about that in its case in chief. So what the state is now saying was the essence of the crime, which was this first contact with Geico on December 7th. One is that's not what the indictment says, and two, if that was so important to the state, it's weird that they didn't mention it in any way in their case in chief, and which gets to the final point I'll make, which is there has to be a coordination between the theory of the case that's presented to the jury at trial and the theory by which the state defends that conviction after the fact. And here, in a couple of ways, supervisor sort of continuing claims over a different period of time, the state has cleverly and ingeniously come up with different arguments that maybe have some validity, but they're not the ones that were made at trial. And I will otherwise rest on my briefs. Thank you.
Thanks, Mr. Tarwell. Break. Yeah, you want a break? Okay. We're going to take just a short break. We'll be right back. Start.